Hello, my name is Maria Martinez, and today I am going to be reviewing price line terms and conditions. Disclaimer: the following information shared in this video is for educational use only. Also, I'm not an attorney, therefore, if you're currently working on your terms and conditions, you should seek professional legal services. Let's start with introducing Priceline, which is an online travel agency for finding discount rates for travel related purchases such as an airline tickets and hotel stay. The company facilitates the provisions of traveling services from its suppliers to its clients. Next, let's explain what terms and conditions are. The legal agreements between a service provider and a person who wants to use the service. The person must agree to abide by the terms of service in order to use the offered service. Terms of services can also be merely disclaimers, especially regarding the use of a website. Jan 2008. Now that we know this, can we say terms or conditions are a valid contract? The answer to that question is yes. They are valid contracts as long as the two parties agree to them. The second paragraph of the Priceline's terms and conditions read, by accessing any area of this site, users agree to be legally bound without limitation, qualification, or change, and to abide by the terms and conditions, which will constitute the agreement. If you do not agree with any part of this agreement, you must discontinue use of this site. Pricelines reserve the right in its sole discretion to amend, modify, or alter this agreement at any time by posting the amendment terms on this site. Priceline.com 2019. However, even though the terms and conditions is a valid contract, there are some terminology that could make them unenforceable. On the most common unenforceable terms is the unilateral amendment provision that gives the business the right to change its agreement at any time without notifying the customer. In the case Harris versus Blockbuster in 2009, was established that precedent in this district that when a contract has a clause that authorizes one party to make changes to the contract without notification, that is illusory, and hence the entire contract is void. With this being said, can we ask the following question: are visitors bound it, or should they have to click I agree? In Priceline, the terms and conditions are indeed bounding the user because they do click I agree to the terms every time they do a transaction with Priceline. In the case Franier versus Priceline in 2012, the judge found that Priceline.com asked their customers in the last line of their checkout process the following sentence: I have read, accepted, and agreed to abide by Priceline.com's terms and conditions and privacy policy. The customer must place his/her initials in a box next to this sentence before proceeding to the next screen. In my opinion, Priceline does a great job bounding their customers to the terms and conditions by requesting their customers to agree to them finishing each transaction. So, does this mean that if I have a dispute with Priceline, can I sue them? Why or why not? If you have a dispute with Priceline.com, you have to give the company 60 days to resolve the dispute. And after that, if you still have the same dispute, you have up to 2 years from the day that they claim to seek arbitration or to take the to a small claims court. Since the terms and conditions are governed by the laws of Connecticut, anyone that takes a dispute to a small claims court can only receive an award of up to $5,000. Pricelines outlines under their terms and conditions the following quote: you and any third party further agree that no proceeding against Priceline, its affiliates, or any travel services provider or for the company offering products or services through the site, under this provision or otherwise, might proceed as a class action, be joined with another person's claim, or proceed on a basis involving claims brought in a purported preservative capacity, either on behalf of the general public or other users or personas. Priceline 2019. In the case Slinger versus Priceline, Priceline avoids liability for resort fees due to its on-site disclosures, which is major. In this case, the result was the same because the court noticed that the Priceline required the user to agree to the terms and conditions with their initials. The court found that this has sufficient support for contract formation. Since price line are very requested their users to agree and sign with their initials before making a purchase, my only suggestion will be to create a pop-up system for every new IP address that interacts with the site to display the terms and conditions with an only option of I have read and agreed to the terms and conditions, and only allow the users to click that box if they scroll down to the bottom of that pop-up. Repeat this option only when a change has been made to the terms and conditions. By doing this, you make sure that your clients have multiple chances to review the contract terms and agree with them, as well as notify them about any changes without making it too annoying for the user. And this is how we get to the end of this video. Thank you very much for watching, and remember, always read the terms and conditions.